And I welcome our nominee, Courtney. And I am Marilyn Petito Devany, and I will be presiding today. So I'm going to, I'll introduce a council. Council Kennedy. Council Kennedy. And with that, I will read the letter from the governor. Dear councilors, I am pleased to nominate Courtney Linnehan to the position of Associate Justice of the District Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I am including the nominees, enclosing the nominees' resume for your convenience. So again, welcome. I first, well, they're not here, but what I first would like to say is that please put your phones away. And I ask the councils all the time if they would stay and remain in their seats for the rest of the hearing in respect to you and to the process. And so the other thing is, if anyone wants to speak, would you just stand now and take the oath, okay? Yeah. Swear to tell the truth, the whole truth, and nothing but the truth. Help you God. Thank you. Okay. So with that, I'm going to start with your witnesses and the order that you have given me. And the first is the Honorable Lawrence Pierce, Associate Justice of the Superior Court. Welcome.
Welcome.
Want to sit down?
See, should I be here?
Sit. Yep. How long has it been now?
10 years since I first visited with you, and 14 years since since I last visited with you.
Had-
First visited.
Had both my votes.
5 years since his 80th birthday.
I mean,
And I can still beat him running around the building.
yeah, but well, you got both my votes, and you haven't been here though. You haven't come.
To testify? A couple of times through the years, but not in recent times. You're right.
That's a while back. Well, welcome,
Thank
and we welcome your testimony.
Well, I am pleased to be here today in support of Courtney Linnehan's nomination to the district court. My name is Lawrence Pierce. I'm a Superior Court judge. I'm now in my second year of recall. Before joining the Superior Court, which was 10 years ago, I served as a district court judge for 5 years. Before that, I was in private practice for 20 years. And before that, I was a Middlesex DA, where I learned everything I needed to know from Counselor Kennedy.
Sorry about
I have been a regional administrative justice for criminal business in Middlesex County since 2016, which was soon after Attorney Linnehan joined the Middlesex DA's office. And since then, I have had a substantial amount of contact with her, mostly in 3 types of proceedings. The first, in the first criminal session in Woburn Superior Court. That's the session where cases are managed until they go to trial. Second, Attorney Linnehan has been in my session in an effort to resolve cases short of trial, which of course is a very important part of the business that we do in any of our criminal sessions. And finally, Attorney Linnehan has tried cases in my session through the years. I will add that over the years, Attorney Linnehan has handled among the most serious cases in the county, the ones requiring the most detailed attention, the ones requiring the most sensitivity. Many have been sexual assault cases involving both adult and child victims. So going back to the first session, I have observed that Attorney Linnehan is liked and respected by her colleagues and court personnel. Her relationship with opposing counsel is courteous and professional. The positions she takes on discovery motions and scheduling are reasonable. She is solid on the law, stands firmly where that is appropriate. Plea negotiations, as those of you who are in the business know, that is an art form, and it's one that Attorney Linnehan is skilled at. She appreciates that cases are more than numbers on a page. The victims are real people. The defendants are real people. From a judicial perspective, the plea negotiation process involves a lot of factors: the nature of the case, the defendant's record, if any, harm to the alleged victim, the views of the alleged victim, penalties, defendant's background, the defendant's particular involvement in an alleged offense, any mitigating circumstance. On top of that, a court is required to layer on how other similarly situated defendants were sentenced, filtering out, of course, implicit bias along the way. So there's a lot going on. After that, you look at the recommendations of the parties, and sometimes you conclude that one recommendation or the other is appropriate. Other times you find a place in between the two recommendations. The point of all of this is a process that, if confirmed, Attorney Linnehan will be able to undertake effectively, given the vast amount of experience that she has in the trial court. For a less experienced nominee, there would be a steep learning curve in this regard. Attorney Linnehan is not vindictive or harsh. Her positions are thoughtful and balanced. I remember two recent pleas that she did in my court. First, in 2021, it was a rape case where the defendant pled guilty to an indecent assault and battery. In the second case, last year, I believe, the defendant was again charged with rape, and during the pendency of the case was diagnosed with schizophrenia. Attorney Linnehan and defense counsel undertook a long plea negotiation process, which involved the provision of mental health treatment. At first, I was skeptical. This was a serious case involving a stranger victim, but what she was able to accomplish was to convince me that this was a disposition that was good for the victim, it was good for the defendant, and it was safe. It was safe because the defendant was not going to be on the street without supervision. Atty Linnehan has also tried two cases in my courtroom, the first in 2018, the second in 2021. Again, both were sexual assault cases. Atty Linnehan is an experienced and a skilled litigator. She is comfortable in a courtroom. She understands the prosecutor's function, of course. She has been one for a long time, but she also understands and appreciates the defense function and the court's proper role. She is clearly not afraid to make difficult decisions, and she does so in a calm and a dispassionate manner. She knows the rules of evidence. She is well prepared, has realistic expectations. In the life of a case, she fights the important battles, not those that are less consequential. So simply stated, I believe Attorney Linnehan has the tools to be a superb trial court judge.
Thank you. Before I call on the councils, I want to introduce the people. The councils have joined us. Councilor Ferrara, Councilor Duff, and I've already introduced Councilor Kennedy, Councilor DePaula, and Councilor Jacobs. So having said that, go away.
Okay.
Does anyone have any questions for the judge? Well, did you?
Oh, no, I just respect the fact that he's the first man to say that he learned something from Councilor Kennedy. So,
I wanted to say how we have to change that 70. And I'm trying to find someone to do it. How crazy is it? He can be a recall judge, he can be 75 and be a recall judge, but you have to retire at 70. If that makes any sense to anybody, I don't know. But anyway, but
Thank you.
now tell me, what case really comes to mind that impressed you the most?
Well, I suppose, I mean, you would think the trials, but it was really the last plea that I refer to, which was a very difficult negotiated disposition of a case with a victim who really didn't want to go to trial, but with a defendant who needed services desperately, and finding the tipping point in resolving a case like that is not so easy, and she did a wonderful job.
So there's no questions, I guess that's it, but thank you so much. Your testimony means a lot.
Good to see you.
It's been a while. Our next witness is the Honorable Marion T. Ryan, my Middlesex District Attorney from Woburn.
Thank you.
Thank you.
Thank you for giving me this opportunity today to talk a little bit about what I believe will be an excellent fit for the district court, and that is the nomination of Courtney Linnehan. You will hear, and I know you know already, and I really want to start by thanking the members of the council. People see this hearing, but what we all appreciate is the hours that go into the preparation that you have done for this hearing, talking to the nominees, reviewing their credentials, talking to other people about that. And as someone who practices in the courts, I am grateful for that. You will hear and already know a lot about many of the things that you're considering for Courtney. You will hear about her broad range of experience, her great trial skills, the relationships that she forms with people on both sides of the aisle, and that is borne witness to today by the members of our office, defense bar, members of law enforcement who are here with us. But I want to take my few minutes to focus a little bit on probably lesser thought of qualities that I think make a good district court judge. There is an essay that talks about what happens or what causes judges, prosecutors, or lawyers to not do a good job. And it says it's not because they're not smart or they're not good people. It is because they just get used to the job and they get used to everybody who's in front of them being the same. That's not going to happen with Courtney. Courtney is someone who sees people for who they are, who realizes and is comfortable in her own skin, knowing that she has had certain privileges in life, privileges that other people have not had. So that makes her able to learn about other people, to evaluate evidence, to think through what the result needs to be. Very importantly, and for those of us who are lawyers, we all hope the judge rules in our favor, but at some point you need the judge to make a ruling, and Courtney's able to do that. She's able to make a decision having gathered all of that information. Those are qualities that I think contribute greatly to a successful district court. District court is really important because you are so close to the action. You are seeing people sometimes just hours after something terrible has happened to them. We share that intimacy, I would suggest, only with medical professionals and religious leaders in seeing people at their worst. And when you do that, you have to see the individual. I've seen it in the 8+ years that Courtney has worked for us. She sees behind the name of the case to the people and what they need. She's comfortable evaluating that case and coming to a decision and standing by her decision. And even when, as you heard from Judge Pierce, the court might be thinking, I don't know if I want to do that, she's very comfortable in doing that. So I am delighted to be here. I am fully confident that she will be a wonderful addition to the trial court.
Any councilors have any questions?
No, great to see you.
It's good to see you.
I'd like to just say, you're almost a neighbor of mine. I'm in Watertown in Belmont. I just want to say how proud I am of you. We all are. And I can't remember so many dangerous, serious cases that have come up in the last year or so that you've had to, I don't know how you sleep at night, God bless you, but I want to thank you for that. So tell me, what do you think is the greatest quality that this nominee brings to the court?
Without question, it is curiosity. I think curiosity is what makes a good lawyer. It certainly is what makes a good prosecutor, and I think it's also what makes a good judge. It is that ability to be, as I mentioned, comfortable enough in your own skin to make inquiry about things, to see people for who they are, to be willing to learn about things. I've seen that with Courtney in her cases, with the 250+ people who work in our office. Courtney knows lots of things about people. She gathers information, and that helps to make informed decisions.
Well, thank you. I think this is the first time that you have come before us.
It's a long time.
Right, yeah, because I've been here 25 years. So thank you so much. Your testimony means so much, and that really is wonderful that you come and talk for her. You're the boss.
It's a privilege.
Thank you. The next witness is Craig Mulcahy. I'm not gonna have any trouble with Irish names. I might said it right.
Thank you very, very much.
You.
It's an incredible honor to be here today, and I'm very grateful for all the attention that you all have given to, I know her as Courtney. Some of you may know her as the nominee or Atty Linnehan, but Courtney's my friend first and foremost, and that's how I've always referred to her. And she's talked to me about this process and meeting all of you and speaking to you, going far away to meet some of you, and all of it's been incredibly enriching and helps me understand and appreciate the process for the people that I go before every day. Courtney and I met in the year 2000. We were assistant district attorneys together in the Dorchester division of the Boston Municipal Court. I don't think it was quite yet the division of the Boston Municipal Court yet. That developed sometime later, but we were together in the basement DA's office. We had 2 desks mashed together with 1 computer and 1 keyboard, and we shared that to do all our work. Courtney came from North County as well. We crossed paths very briefly in our movements career-wise, but we didn't know each other in Norfolk County. I got to know her in the Dorchester court, where you get to know people very quickly because of the intensity, the activity that goes on there. And as we just heard from District Attorney Ryan, we did see people at their very worst, often, if not hours, sometimes minutes after they'd been peeled off the street or dragged from some location because of an allegation or an incident that occurred. And what I learned from Courtney during all those experiences was how much care it took to read a police report, and not just to read the words on the report, but to make an assessment of the situation, to take the situation in as a whole, sometimes in as little as 15 minutes, but often with a lot more time. And starting with that foundation, you could then build your theory of the case and what you thought was the right thing to do. And in all my experiences with Courtney, she's always done the thing that she knew to be the right thing to do. And ultimately, I don't think anybody could ever quarrel with that decision. You might not, you might have wanted to do it somehow differently, but the ultimate outcome, I think, was unequivocally correct. And one of the things that I think of when I think about Courtney is her decency. We heard some of that already. She wants to know about everything, not just what happened to the alleged victim, but what's the circumstances of a defendant. She was a defense attorney for a time. She was a divorce attorney for a time. She taught me how to be a divorce attorney. She taught me in many ways how to be a defense attorney. And she first and foremost taught me how to be an assistant district attorney. She's a teacher, she's a mentor, but first and foremost, she's a friend. And I can't think of anybody who'd make a better impact on the district court than somebody with her talents and attention to detail.
Thank you. Any questions from the counselors?
Oh, good to see you.
I'd just like to ask you, is there any case that you worked on that you will always remember and that it was really meaningful?
Yes, I can tell a story on myself. One day in the Dorchester court, I showed up in street clothes because I thought I had an office day. In fact, I had a trial that involved a victim, and no sport coat and no tie. I briefed the case with Courtney for about an hour. She went up, she tried the case and won. And the guy was found guilty. There's another case that I think is important to talk about. She's had all kinds of victims, all kinds of people that she's trying to help. One of the cases that she was working on in the last several months involved a victim with special needs. And she had talked to me about her efforts in working with that person so that they could explain the situation, what happened to them. And it's one thing to do that in an office and in the comfort of an environment where everybody's kind of your friend and everybody's kind of on your side. And what moved me about that experience for Courtney was her efforts in helping that person appreciate the much more imposing reality of going into a courtroom and actually telling her story. And as far as I know, Courtney was able to move that person into that ability and for a successful prosecution. And that's all I really need to say about it, to give you all the impressions that you need to make this nomination what it should be, which is permitted to go through.
Thank you. Your testimony means a lot. Thank you for coming.
It's great to be
So
here.
that concludes our witness list. Oh, I'm sorry.
There was another young lady that wanted to speak that's not on the list.
Oh, I'm sorry.
I was waiting until you called for anyone else to come up.
Okay, would you like to sit down and tell us your name? Thank you, Counselor.
Good afternoon. My name is Karen Goldenberg. I am
I'm sorry, what is your name again?
Karen Goldenberg. I decided to come today and talk about Courtney because I think it's important for all of you to hear from opposing counsel. I've been a criminal defense lawyer for over 20 years. And I have tried cases against Attorney Linnehan. Specifically, we tried an aggravated child rape case, and we until recently were opposing counsel on a first-degree murder case. And I am hoping that Ms. Linnehan will not be working for the DA's office by the time that goes to trial. She has a new job, hopefully. I think that Attorney Linnehan is exemplary, both as a lawyer and as a person, and will make a fantastic addition to the district courts. A prosecutor has a very special role in litigation. The other lawyers who are trying to win their cases, they have an obligation to do justice. And Attorney Linnehan does just that. She's very forthcoming with the weaknesses in her case, with exculpatory information. And I never had any concerns in cases with her about something being kept from me or fixed in a way that it shouldn't have been fixed. I also wanted to mention that Attorney Linnehan is a very kind and compassionate person. We were opposing counsel on this child rape case for several years. There was a delay because of COVID-related foreclosures. And during that time, my mother died and it was awful. And Attorney Linnehan not only assented to all the many continuances that I requested, but she was also really supportive. She had gone through the same thing a few years earlier. She was also dealt with a father who didn't really know how to be without a wife, and gave me a lot of advice on how best to deal with support my father. Very appreciative of that. I still am. And I hope that all of you will vote in favor of Attorney Linnehan. She's exactly what the district court needs, a person with integrity and great character. Thank you.
Thank you. Any questions?
Thank you. Thank you.
You're being quiet today. I just wanted to say that to have an opposing counsel, that means a lot to me. That you went out of that court. I don't know who won the case, but you had respect for her. She won. Okay, that you had respect for her. And I think that's the most important thing, whether you win or lose that case, to have respect for each other. So your testimony really means a lot to us. Thank you so much for coming. You can be here. Now, is there anyone in opposition? So having heard none, oh, I forgot to introduce Councillor Iannella.
Good afternoon, how are you?
Do you have any questions, Councillor? So this one? Yeah. Okay, so having no opposition, now, first of all, I'd like you to introduce all the people that came here for you.
You've met all of my witnesses and you met Attorney Karen Goldenberg as well. I also have here my husband, Abdel El-Meme, my sister, Shauna Wood, my mother-in-law, Roger Wood, my dear friend, Kimberly Pastor, and then I have a couple members from the Middlesex DA's office, Joanne Cito and Megan McDade. Then I have Lieutenant Blaise Tersoni from the Framingham Police Department, Detective Darren Crawford from the Framingham Police Department, Judge Michelle Armoire, and my friend Ann Yaz, who I've known for 25 years, maybe.
Wow, that's great. Thank you all for coming. Now it's your turn to make your presentation.
Good afternoon, members of the Governor's Council. I am honored to be before you today as a nominee to Associate Justice of the District Court. I want to thank Governor Healy and Lieutenant Governor Driscoll for their confidence in nominating me to Associate Justice of the District Court. I also want to thank the Governor's legal team, Paige Scott Reed and Dara Kesselheim, for your guidance throughout this process. Thank you to Valerie McCarthy and her team. Also, thank you to the members of the JNC for their consideration and support. Most importantly, I want to thank my husband for everything that he has done to support me over the past several weeks, and especially, or I should have said over the past few months, especially over the past several weeks. If I am fortunate enough to be confirmed as a district court judge, it will be my job to ensure that people are treated fairly and with dignity, and to help people address the underlying issues that have brought them into court. I would like to share with you briefly a few of the personal and professional experiences I believe have prepared me to do this job well. I am fortunate to have had a comfortable childhood with a supportive and loving family. In many ways, my upbringing is unremarkable. My parents, however, were remarkably insistent that I experience as much of the world around me as possible. My parents encouraged me to always try new things and experience firsthand the different cultures around us. They taught me that there are so many different ways to do things, and I should always be open to new experiences. Sometimes this was as simple as trying a new food or attending a religious service with a friend's family. When an opportunity presented itself in high school to spend the summer in a culture vastly different from where I was raised, my parents made sure I was able to do this as well. My parents' insistence that I experience everything at every opportunity has in many ways shaped who I am today. Along the way, I met people who were very different from me on the surface. I saw poverty I never imagined. I got to know people who spoke different languages, who wore different clothes, who ate different food, and who thought about the world in different ways than I did. But my parents always told me that people are the same underneath the surface, regardless of how different they may appear on first impression, and to remember, no one's life is easy. Those early experiences and my parents' message have stuck with me and shaped me who I am as a person and as an attorney. I have spent my career representing or trying to give a voice to individual people. I worked as an attorney in my own practice, representing individuals, often defendants. I have worked for many years as a prosecutor, and much of my work has been focused on giving victims a voice in court. The people I have represented or tried to help are very different on the surface, but underneath, in many ways, they are the same. And whether working with victims or working with people accused of crimes, I've always started by trying to find commonality. Even though my life experience may be different from theirs, there is sameness in the experience of emotions and often the experience of loss. Finding commonality has been the first step in being a good attorney for my clients and has prepared me, I believe, to be a good judge. Often victims or clients assume that I will not understand what they are going through because I'm an attorney or because my life has been relatively comfortable. But I have been able to draw on the events of my own life and the values my parents instilled in me to relate to the hardships that they are going through. No one's life is easy. My life has had some challenges. I lost both of my parents at a relatively young age. My husband is an immigrant from Jordan, and English is his second language. He is frequently treated differently than I am, based on his accent, his name, and the color of his skin. I have been able to use the experiences in my life to empathize with victims and clients who are often experiencing much harder challenges when they come to court. One of the reasons I particularly want to be a judge in the district court is because in the district court, people experiencing hard challenges are often given a second chance. The judge has an opportunity to guide them onto a path or into a treatment program where there is hope for redemption and rehabilitation. As a judge, I would work hard to understand the underlying issues that brings a person to court. I would value the chance to help them find the way to address their underlying problems so they would not get stuck in a cycle of committing crimes based on mental illness, substance abuse disorder, or any other underlying issue. When people have the opportunity to address the underlying cause of what brought them to court, the community becomes a safer place. I believe that my professional experience of understanding the perspective, not only of a victim, but also that of a person accused of a crime, will make me a more compassionate judge. If I am fortunate enough to be confirmed as a district court judge, I will draw on all of my experiences, both personal and professional, to ensure that the district court is a place where people are treated fairly and with dignity, and where people are given an opportunity at a second chance. Thank you for giving me this opportunity to address you today, and I look forward to answering any questions you may have.
Thank you. Counselor Iannello, questions?
Very much. District court is a community court. In your community, wherever you live, are you involved in any activities or programs?
I have been, and for a number of years, I was a member of the Milton Junior Women's Club. That's an organization that brings women who live in the town of Milton together. There's a road race that they have every year, and the funds raised from the road race are then used to provide scholarships to kids graduating from high school, and to help them fund college and purchase books. During the pandemic, I actually stopped working in that particular organization, but I did that for a number of years.
Okay. I know Milton does not have a district court. Okay, the closest one is this one. You go to Quincy or you go to the
You go to Quincy.
Quincy? So you're confirmed. And now you have, a low level. So-and-so's in front of you. And they're from Milton. They're not your best friends, but you know of them. You know the defendant's parents, as really respected people in the community. And you've met them on a few occasions. You're human. What do you do in a situation like that? Do you recuse yourself, or do you, let's just they want a bench trial? What do you do in that situation? Because it is awkward.
Right. So I think depending on how well you know.
Your best friend, seen him at a couple of social events in Oakland. Oh, I have Joe, but you haven't gone out to dinner with him, but you clearly know that, and they know you.
I think in an instance like that, it would be very important to disclose that to the parties involved in the case. And disclose your relationship, give both parties an opportunity to state on the record if they have any concerns about that. And then ultimately, the judge has to decide on whether they feel that they have a bias that would interfere.
So, let me ask this, well, it could be either one. Say the ADA says, I want you all. Like you finish yourself. What are you doing now?
I think if one of the parties is uncomfortable with it and requests the judge to recuse themselves, it seems to be the more prudent decision. In a position where you may have a bias.
Hey, it's awkward. You don't want to be put in that position, and 2 weeks later you're seeing them. Who knows what could happen? I do agree. I've always thought, and I've been on the council a few years, that once a prosecutor, and we talked about this, always a prosecutor. You've been a prosecutor on and on, 15+ years.
Yes.
I'm a person living. No question. If I was a judge, as much as I say, oh, I'm going to be fair, don't worry. You tend to be, in my situation, pro-plaintiff, pro the injured person. And it's hard for me to believe, and they all say, oh, not me, don't worry, I'll be here. Oh, but in reality, what's your box?
So, well, I think being a judge is very hard to begin with. But to answer your question specifically, you're right. I have spent more of my career as a prosecutor than I have in doing civil or as a criminal defense attorney. But I have done both. I have sat next to an individual at trial on a life felony case. And I have, worried about the outcome in that case and would my client, potentially go to jail for up to life. And I would take that experience with me. I do take it very seriously. And I have sat in Superior Court next to people who could be going to state prison for 15 years, 20 years, or life.
Yeah, but most of the lawyers that I talked to, over the years, what did you confirm so-and-so for? Didn't you realize it was a ADA from Norfolk? What are you doing? I hear that a lot. I mean, to me, the ideal candidate for a judgeship is a sole practitioner who's done, I don't care if they've done criminal or civil, but a sole practitioner. I just feel like it's so hard. You're a prosecutor. It happens all the time. And I hear stories all the time. Oh, bail. And you gotta be able to bail, like, you're not gonna be a rubber stamp for the prosecution.
No, and one of the things we talked about when I spoke to you on the phone is we talked about it's not that recent, but it's a fairly recent SJC decision and the mandates it has for a judge to set bail, a reasonable bail, a bail that a person may be able to meet. And I have seen judges, ask, defendant, how much money do you have in your pocket? How much money could your family make? Do you think you could raise that money in a week or 2 weeks so that the bail is set at something the person can make and they won't be held without bail for a year or more pending trial?
So in a hypothetical where someone has what I would consider medium criminal record, not like 10 pages, medium. And his attorney, able attorney, Counselor Kennedy, so he's one of the most esteemed defense attorneys of the Commonwealth. He comes and says, the guy's got no money. He can only, in his family, his father lost his job, and they're struggling just to pay the bills. All he can come up with is $100. And if anything more than that, he's gonna be in jail for a long time. Yeah, we know some assault and battery, but no one was hospitalized, but it was assault and battery with, with a screwdriver, okay? And the ADA is saying, I'm gonna follow the statute, I have, basic decision. I think it's reasonable, $500. You're a Kennedy, you know, what are you gonna do?
If the person, as you said, has I think your word was moderate record, they're a member of the community, it sounds like. And if they don't have any defaults, it sounds like $100 is a reasonable bail for that particular person.
I mean, I don't do criminal work, but I totally believe, disrespectful. That's hard for me to believe, that all these APAs, 500, no. Kennedy says 100, I'm going 100, that's reasonable. This one here, yeah, I'm going with it. I don't know, man, I totally believe you, I respect you. It seems to me, it's hard to believe. I mean, it seems unrealistic. And why do I say that? Because I think a lot of judges, not just real, a lot of judges are afraid of the newspaper. Okay? And they're afraid of the newspaper. You let them know $100 cash bail. The assistant DA was looking for $500. Guess what? Operating under, someone is seriously injured. This right here, Linnehan, let him know too early. We never should have let this guy out. Are you concerned about that?
So I think as a judge, it's important to look at all the facts and circumstances. As you said, You mentioned his record, the facts of the case, whether they have faults on their record or not. And something that I think you and I talked about on the telephone, what is a reasonable bail for one person in one community versus a reasonable bail for another person may be vastly different, and it might be a high bail for some people to come up with dollars.
And don't you agree that a Judge Linnehan has to think that this bail is reasonable, but Judge Farrell over here, that bail is ridiculous. So you always want to have that situation, right? So, yeah, I think it's, I used to do it when I first started, I used to do court-appointed work. And I was in this court, that court, long story. I felt that nothing's changed. A lot of people want to form this. But I think, but I think most people, 95% of the time, the judge would follow the recommendation of the ADA, the bail situation, and the defense recommendations. What are your sense on that?
So my experience, both as a defense attorney and as a prosecutor, going back to when I started in district court, and I do want to add, I started in Dedham District Court, and a little later I went to Dorchester, and a reasonable bail in Dedham and Dorchester are miles apart. But in my experience, I have found the judges I have been in front of have listened carefully at bail or at sentencing to the facts of the case, the position of both parties, and that I feel that most of the judges I have worked with do not always come down with the prosecutor.
Okay, we should follow up on that. So your case, you're sitting in Dedham, and then next week you're sitting in Dorchester. There's, I don't know, actually staff, but there's a lot more crime in Dorchester. And you're giving those people, which would be, I wouldn't like that, because there's a lot of people, there's a lot of minorities in Dorchester, represent Dorchester, represent that. Are you gonna give them a higher bail?
No, it would be based upon cases that have indicated. I think a reasonable bail in Dorchester is going to be significantly lower than a reasonable bail in a different community.
Okay, you have a situation, you're in Dedham, and what you think. Then you go to Dorchester, you go there for a month, the chief or the head judge in Dorchester, I'm sure the terminology says, we have, because this used to be way back when in Quincy, where the judge says, I think it's Judge Kramer, Kennedy, but Kramer used to say, any operating under, this is what you have to do. I'm the head, the chief in this Quincy District Court. That's what I want everyone to come in. The judge was saying that mine would follow suit. What would Judge Linnehan under that situation?
I would evaluate each case separately. Given the charge, I would look at the person's ties to the community, any history of defaults, and what amount of money is reasonable to them, and make a decision that I felt was appropriate.
So he wouldn't follow the court rule, I'll call it, from the chief of that court.
I would follow the laws of the Commonwealth.
Okay. What do you do in this situation? You're in, the case was continued until today, and you're the judge. They call the case, no further continuance. Perfect. And now, we're going to exaggerate here, I'm sure they don't do it. Under no circumstances, no further continuance, this has been on twice before. What are you doing? Are you going to follow that? You can say, I don't care about what the previous judge says, I'm doing what I want.
I think that it's important for the judge to consider what's on the docket, but then you also have to look at the parties in front of you. If somebody is asking for a continuance, you have to look at the reasons why they're asking for a continuance. Is somebody in their family sick? Has somebody in their family recently died? Sure.
Overall, well, he's. The attorney says, you know what, I was on trial last week, you know, today's Tuesday. I got off the trial Thursday. I haven't had a chance to fully prepare, and I don't think I can give my client adequate representation. But remember, this has already been continued a couple of times. What do you do in a situation like that?
If an attorney indicates that they are not adequately prepared for trial because they were on trial, it's important that their client have the best possible representation, and I would grant them a continuance.
I like that answer, but I gotta tell you, in reality, that doesn't happen.
Sorry.
I think I told you about 3 instances. Okay, listen to this, folks. I don't even care, it's my office. Okay, one of my lawyers, his wife was due, I don't know, April 5th. Case was out, wherever, I'm not gonna tell you the judge's name. It was on for April 12th. Judge, I need a continuance, my wife is due, what if she's, you know, late or early, if you get the kids. No, let us know if baby comes early or late, whatever, but and he was furious, rightfully so, because now he's gonna prepare, he doesn't know when. What are you gonna do in that situation?
I would grant the continuance. I think it is unfair to put that attorney in a position where his wife is on the verge of giving birth. He's preparing for a trial when he has the birth of a child also on his mind, and continuing a case for a month or two and allow him the time to enjoy the birth of his child and be prepared for trial. There's probably another case that can go to trial that time.
These are real stories, I'm not making them up. Then there's another, one of the other lawyers on the council had a case, he wanted to go on vacation. Think about that, you guys go on vacation, vacation. I'm not gonna say it exactly, but, you know, on Monday, so he says to the judge, I need a continuance. You know, I'm taking my wife on vacation. Well, don't you have another lawyer in the office who can handle the case? And the attorney goes, oh, it's just me. And even this person had other people in the office. The defendant hired this person. He doesn't want you or me. But these things happen. Finally, because it was a while ago, but the bottom line, it was a hassle. He had to go to the court a couple of days before he's gotta go on vacation in person, not Zoom, and finally the case got continued. But that's a lot of work and to me unnecessary. Your thoughts?
I agree with you. As I said to you when we spoke on the phone, one never knows when your last vacation is going to be. And I think it's important to respect the parties' family lives, vacation schedules. If something comes up and you have a wonderful surprise trip, the case can be continued.
She remembers, we talked, that was the other one. Imagine this. Yeah, she's not. I told her, I asked, someone was sitting in that chair. I asked, what are you gonna do? If your spouse says, oh, I forgot it was being a woman, right? We're going on vacation. What's today? Today's Wednesday. It's Monday. This is all exciting. He's going to Bermuda. What would you do? No. I'm supposed to know about the person's work schedule. Never should have made a reservation without going over the, you know, the plans with the spouse. That's crazy, but these things happen. I don't make these up. They're all true stories. And again, I'm gonna call you if you do it. You're not gonna stay.
Please do.
But no, these are crazy things. And always remember one other thing. You've been an assistant DA, and as an assistant DA, you don't care about the rent. It's not your problem. You don't care about the lights. It's not your problem. You don't care about the secretary. Not your problem. I go on and on. Remember, an assistant DA, if you're not there, you can get someone else in the office to handle it. But that sole practitioner can't. And that sole practitioner is gonna make a livelihood, because he's got kids going to college, or he's got kids who's gonna get sports equipment for. So I hope you're gonna be cognizant of that fact, because it's a tough world out there. And you never know where your next dollar is gonna come from. I hope you'll remember that. Well, thank you. We had a nice conversation. My good friend, the clerk of the BMC, Dan Hogan, called me. Speaks volumes. He thinks you're great. And when your name comes before the council next week or the week after, I'll be more than happy to support you.
Thank you, Councilor Ianella. Councilor Duff.
Thank you. Great to see you. Two questions. LGBTQ kids, people, do you have much experience working with this community in the courts?
So I do actually, first off, I would say it was about 17 years ago. I tried a case, I was an ADA, and it was a sexual assault, and the victim was transgender, serving a sentence at Nashua Street, which is a male facility, but identified as a female. She had to be transported to court every day. I filed a motion asking the judge if she could change before testifying, and not just change out of a jumpsuit, but actually change into clothes that she wanted. For example, we had a sweater and a pair of pants, but that she could dress as a female because that is how she identified. So that I had that experience many years ago. The judge did allow me to do that, by the way. Additionally, I work in the child protection unit, and many of the kids who come into our unit are part of that community. Many of them are transgender. I've seen children come in for their first interview, and they may identify as a female. You go to get ready for trial, and they identify differently and have a different name.
Thank you for that. And I'm glad you have the experience. What is disturbing to me, and the reason I ask it, is because there is so many of these kids in our criminal justice system. And the reasons why are not good reasons. In my experience, I'm not where you sit, or Marion Ryan, who I have the utmost respect for, but some of them are not welcome at home. They don't feel safe at home. They don't feel safe in a foster home, or they've been abused, sexually or otherwise. And sometimes these kids end up on the street, where then, you know the story. We've seen this movie, right? The drugs, the violence, the prostitution, the crimes that happen. And they end up in this gerbil wheel in our system. And, I get sick of hearing myself sometimes, but as I've said many, many times before, it's hard for a lot of people to get their heads around this particularly transgender issue. But from where I sit as an adult, and as someone who's been elected into this position, I should be held to a higher standard, as you are as attorneys and ADAs and as judges, that we're here to protect the children. And that was the word that you used, is that these are children. Thank you for that, because I think I think that's what folks have to remember more than anything, is the children. And it's our job, no matter what path they're on, wherever they go, it's our job to make sure they're safe. Second category of folks, and you and I spoke about it, personal to me, but also, folks that I think are very vulnerable, are folks who may be, as we used to say, on the spectrum, intellectually disabled in some ways, but particularly those who could come in front of you and you may not know by looking at them that there's some disability there. You may have, as ADAs, had experiences where you have conversations and everything seems dandy and it's all going fine. And then all of a sudden, you're in the middle of a hearing or something, you realize this something's not what I thought it was. And so I before I ask you about, my question is going to be same thing, experience with this. I do want to say, I think our courts and our chiefs have done a tremendous job of trying to educate and starting to educate people about these issues. As I said to you, and I've said to others, it does not absolve you from a crime if you have an intellectual disability or a special need. But it should impact how you're treated in the court and what the sentence is. So anyway, could you speak to that?
Absolutely. I agree with you. I think the courts, I should say, have come a long way in accommodating to appear in court who are on the spectrum or who have any number of disabilities. I think we can always do better. I think the courts have also gotten better dealing with victims or witnesses who also need accommodations. My first Superior Court trial was a sexual assault involving a young man who was disabled. I have had many cases with victims with disabilities and have asked the court to accommodate them, whether, it's taking more breaks for them. Sometimes a person may need a microphone because they're so soft-spoken. And what I've tried to do is find out as best as I can what they need and ask them to tell me what they need.
Yes.
Sometimes they can't, and I have to do the best I can to say, gee, Your Honor, I think they may need this. Can we do that?
But thank you for that, because again, our job is to protect them and to serve justice, not just punishment, but justice in that there is a line between them. And sometimes the line intersects and sometimes it doesn't. But, and I think our last, one of our last frontiers, although everything changes so quickly right now, is, people with physical disabilities. Are our facilities, jails, prisons, courthouses, accessible? And the one thing I know for sure, as a person who is now officially middle-aged and maybe getting a little closer to the not middle-aged, older, that I will be considered disabled at some point, either for my vision or my hearing or my mobility. And, it could be my intellect too. But these are real things, and again, it's not other, it's us. And so just that awareness, and I know, that's, to me, this is a real tough one, because I know some of these buildings aren't as accessible, and I know we don't have the technologies in all places to make them as good. But just knowing, that's step one in it. So that's my presentation on that, and I have no further questions. Thank you, Madam Chair.
Thank you, Council. Council Kennedy?
I don't have any questions. We spent a lot of time together. Through this process as well as in the courtroom. I know how qualified you are.
Thank you. Is that it? Okay. Thank you, Council Kennedy. Council DePaul.
Thank you, Council.
Questions?
Thank you. I do. Good afternoon.
Good afternoon.
We had a good conversation.
Yes.
Councilor Kennedy told me to be extremely difficult on you. That's not always my style, so I'll do my best. Whenever a nominee has overlapping experience with me, however minor, it's very helpful for me because I understand it, and hearing their perspective on it helps me understand how they approach things. So this morning we had a nominee who unfortunately had done asbestos work, and unfortunately I had as well. It was very helpful when I spoke with him to hear his perspective on it. So all I did was spend a summer there, but I was in the Suffolk DA's child abuse unit. And I hope that my supervisor at the time, Nancy Hathaway, ends up where you are in that very seat someday as well. But that was a very eye-opening experience for me, and it really kind of changed the trajectory of my professional and personal life. I'm wondering, how did your experience, and you've spoken a little bit to it, and I don't want to hear the details of horrific child abuse, please, but I would like to know how the experience, seeing what you saw, how it's impacted your approach to things since then, if it has.
Oh, it absolutely has. I think, given the work I've done, with children, who have been physically or sexually abused, so much of that happens in private, and it is not often that those people come forward. And I like to think in my day-to-day life, I take into account that you never really know what another person or another family is going through. And also, you know, in my experience as an attorney, even though I'm currently a prosecutor, I don't know exactly what a person accused of a crime is going through. I don't know what their history is. I don't know if they've also been a victim, if they have a trauma history. So I think everything that I have learned over the years, I try to take with me, not just professionally, but also personally.
And you probably would agree that folks who've been victims of trauma aren't forthcoming always, right? Especially in an intimidating context like a legal proceeding, whether it's just meeting with a lawyer or whether it's in the courtroom. So, I mean, it seems an impossible task as a judge to be able to know these factors when you're exercising your discretion regarding a particular defendant. Is there any way to get to?
So I think as a judge, you often rely upon the attorneys to provide you the information, in a criminal case, whether it's the victim or the defendant, you really rely on them to provide you the background of this person. There may be some information that you may know as a judge where you're able to ask the attorney, I would like more information about this. I'm concerned that your client may have, you know, a trauma history or have come from a family life that was somewhat difficult.
If I could interrupt you. So I would imagine with your expertise and the resume you have that you are sensitive to identifying when someone is reacting out of a place of trauma. Would that be fair to say?
Absolutely.
It would be in your discretion if you felt that way to hold an evidentiary hearing should you desire.
Yes.
Before making a disposition, would that be true? Or before crafting
So I think a judge often has as additional tools other than just asking the attorney for more information. A judge has the ability to ask for an aid in sentencing, which can be done by probation. Sometimes depending on what the individual is saying, maybe it's more appropriately done by a mental health professional. But something like that can be very helpful to a judge in fashioning a sentence that addresses the concerns of that particular person.
I just want to ask one more thing because I don't practice criminal law, but I talk to folks who do. And one thing that folks have been talking to me a lot lately about is the use of GPS and whether or not it's being overused in some cases where it's not actually a targeted tool to the particular situation or defendant. To take it to an extreme example, I've been told of situations where folks are being held for want of a GPS unit to attach to them. I'm wondering what your perspective is on that, because I don't purport it to be pervasive, but I do hear it, and it's on the margins where our excellent court system should be paying attention, right? Because we do good in so many areas. So what's your perspective on that?
So I have heard that as well. I have heard about people sitting in jail waiting to get a monitor like you have. I have also had cases with defendants whose monitor is broken, and the closest court that they can go to could be a half a day's drive, and they don't have a car to get there. So I think where GPS, where the court orders a person to be on GPS, the judge has to consider the law, because under the current decisions, GPS is being imposed both pretrial and post-conviction, fewer and far between. But if it is a case where GPS is ordered, it is appropriate, I think it's important for the court to recognize that not everyone can get to a courthouse to get a new beacon or device within the time where warrants sometimes issue, and unfortunately they get arrested and held.
I'm not gonna ask any more questions. I appreciate your temperament, especially based on people I've spoken with, and yeah, I've appreciated your attention to the particular nuances of people. So thank you, Counselor.
Thank you, Counselor Jacobs.
Thank you. Good afternoon.
Good afternoon.
It's good to see you.
Good to see you too.
I want to start off by saying how much I appreciate that you came out and the time we spent together. And I'm pretty sure that your husband was your driver. And so I thank you for being the supportive co-pilot in making that happen. And we had a really great conversation that was broad and far-reaching. I'm going to start from where I started with that conversation and just say that I'm fairly new to this, and so, you know, others may not have been quite as startled, but your cases are just so intense. Like the number of just very difficult to read cases in your application just sort of set me back. And so I can only imagine experiencing, you know, it on either side of the aisle when, you know, as a prosecutor or if we're doing private work, being personally invested in some of these cases. But I would like to give you an opportunity to speak to it, but my feeling is that coming from that, it's only led you to have an extra awareness and appreciation around trauma, sensitivity for victims, you know, just in general. So I'd like to give you an opportunity to speak to, from your perspective, how that'll impact you as a district court judge, having been involved in so many of these extreme scenarios.
So I think my experience having worked, not just with victims who have a trauma history, but when I was a defense attorney, many, if not all of them, also had a trauma history. I would take all of that with me. As I indicated, I think just a few moments ago, it's really important as a judge to consider that in a disposition, to understand what is going on with that particular person, whether it's trauma history, if treatment's available, whatever the underlying issue is. It's important to try and direct them towards an appropriate treatment that will help them with that issue.
So I would hope, given this, your experience, you're very aware in your communities, what resources are available from a diversionary standpoint. Would your inclination as a judge be to avail yourself in judgment in finding potential, or how would you approach diversionary programs in terms of how would you determine who you would want to send to that kind of a resource versus let them get programming while in jail, you know? You know.
So I think in terms of people going to diversion, there are several factors the court has to consider in doing that. Some of which are, you know, what the person's prior record is or lack thereof. Also what they're being charged with. Is there a diversion that would be appropriate to them? And I would like to think that I would take all of my experience, and where a person is eligible for diversion, let them have that opportunity.
I appreciate that. So one of the areas that I wanted to explore with you is the evolving science around emerging adulthood. And you know, just it's an area of concern for me looking at our incarcerated population. The vast majority of those incarcerated in our state, their originating offense was during this emerging adulthood period. You know, district court can be that first foray. And the outcome of that experience feels like, you know, the movie Sliding Doors, where it could go this way or it could go that way. It's like, you know, what pathway is this person, you know, where are they headed? So I would just like to hear, your thoughts around the emerging science and the implications in the courts, but also as a judge, how you would proceed in sort of keeping that consciousness around, you know, who's before you and and sort of,
Well, as you indicated, many of the people who first come into court, and usually the district court, they are young adults. And I think it is important as a judge to consider all of the factors. And one of the factors that must be considered is the person's age. And with a young person, as you mentioned, it may be an appropriate time to get them into some treatment or a program that would help them. And I think it's important to consider that because, as you indicated, it's possible that your first appearance in court as a young adult may send you in one direction or another.
I do think, having spoken to people who've been court involved, judges can really, they can make a difference. They can be inspiring and motivating and underscore that, here's someone who believes in them and what they could be and send them into a positive direction, or the reverse can be true. So it's important to me that, from the bench, ideally we have judges who are doing positive work, especially at the district court, frame the community court. I want to comment on one other, or actually maybe two other things in your application. First off, I said this to you when we met, but I very much appreciate, let me find it. There's a question on the application that's asked of everyone that is about whether or not you belong to any organization that discriminates. And so far, you're the first application I've seen that the answer is not no, even though there's been like things alluded to that are kind of self-limiting memberships. You're the first to actually just acknowledge it and just say, why, yes. And you've already talked about your work with the Milton's Junior Women's Club, and so it is for women 18. So I just want to validate and applaud you for just owning that. And I would encourage others to just be frank about, there are clubs for a reason that are for a certain group, and doesn't necessarily imply malicious, malignant reasons. And then we were talking. There's a part of your application, we asked why you want to become a judge. And in your answer, I had shared with you the line that jumped out at me, which is that it's one of your closing line in that section, that every decision a judge makes pulls at a thread that impacts every aspect of a person's life. And it was a powerful statement to me. And when I shared with you that it was a powerful statement, you actually went deeper and further, making an even more powerful analogy for me about knitting and pulling on threads. And so I just want to give you the opportunity to share that with all of us, because I appreciated it.
Sure, absolutely. But what I'm referencing there is something in needlework and in particularly knitting. But I assume in all needlework, if you pull the yarn tightly, the entire piece will shift in one direction, and it affects the shape and the entire course of that scarf, for example, that you might be working on. And I do feel that decisions that judges make can have the same effect on not just the person in court, but their family and their greater community.
Yeah, I think that is so true, especially district court, but I think all of our courts, there's a greater picture that person, represents one facet of a much broader contextual community impact that can happen. I just very much enjoyed our conversation. I think I'll just validate what I've heard from others said today. My impression too is your demeanor is exactly what one would want to see. Your life experience has just led to, I think, will contribute to being a really great district court judge. And I'm glad to have met you, and I appreciate all the time. I hope it's been a good experience.
It has. Yes, thank you.
Thank you.
Thank you, Counselor. Thank you for all the time you afforded me. It was such a pleasure meeting you. You are unique. I've been here 25 years and I haven't had someone before me that really has been involved in disabilities. And that concerns me. How many judges really understand disabilities? I served on the Commission on Disabilities for 22 years, so it is, something of importance to me. But I'm impressed that you've gone beyond to learn more about it, because we have disabled people that are being raped and assaulted by paraprofessionals in schools and hospitals. And got a letter from the Child Protection Unit, and she, Joanne.
Cito.
Oh, yeah, and she talked about that you consulted with one of the preeminent experts in crime victims with disabilities. That says a lot. I don't know how much education our judges have on disabilities. And transgender, this is, fairly new coming in. How many really understand? I don't know. Is there any program? Do they educate? Did you get educated on it, or, on this subject?
So I'm assuming that the courts have many educational programs, but I don't know that yet. My office, does a lot of trainings and education on bias, in particular, implicit bias. But also with, when you reference, the case, that Joanne Cito wrote about, that individual, I had to learn about his disability so that I could understand him and I could help him get through the court process. And was lucky enough to have available to me an expert in the field of disabilities, in particular with children, who've all spent a lot of time talking to me and educating me.
The thing is, transgender is everybody's learning, I'm sure. But I don't know if you saw the Globe, it was yesterday or the day before, and there was a girls' team, and there was a man that was transgendered, and 3 of the girls were injured. And I don't know whether that's just isolated or what, but the coach, it took that right out the game, right out of the spectrum at all. And I thought that was a noble way to do it. But there's a lot of things that have to be, looked at. So I hope that there is some educational program for the judges to understand, So one of the things that I can't even imagine being involved in all of these. You've had a lot of rape cases with children, horrendous what some of these children have gone through. And, I'm very opinionated, and I follow the Harmony Montgomery case. And I blame the Massachusetts judge. If he hadn't given custody to the father, she was going to be adopted by a couple who adopted Harmony's brother. She had a little brother that asked for her every day, and they were trying to find her to adopt her. So enough said, because I'll get upset about that. But the thing is, you had a 3-year, tell me about that 3-year-old, the case of the 3-year-old.
Sure. I had a case where I helped a family reunite. My client had custody of a family member who gave birth to a child when she was approximately 16 years old. And he then had custody of her baby, which was a little boy. At some point in the process, the mom had moved out and she was having visitation. And at some point, due to a clerical error, custody was returned to the biological mother, who unfortunately suffered from mental illness. And during an episode, she attempted to kill her young child. And I worked with my client, who was an uncle, to reunite the family. There was a care and protection case, and I was able to work with my client and help him get the child placed with him in Georgia. And then ultimately, he was able to adopt this little boy, who I have now heard is in college. So I'm not sure I should call him a little boy anymore.
You've had, I'm just reading these cases. I can't imagine you having those cases and going forward to it. So that shows me how qualified you are to be a judge because I've been here 25 years and people don't have this experience, you know, because you've had a lot of children that have really horrific cases. There was one that was the mother died and she was 1 year old. Remember that case?
It was a rape case I had. The victim was 16 years of age when she was raped by a classmate. Her father had died when she was a young child. Her brother had died when she was an adolescent, and then her mother had died. And she appeared at school during the day of the MCAS test, and she was extremely intoxicated and passed out in the woods behind the school when she was raped. And ultimately, she didn't testify at trial because whenever the trial came up, it would cause her to spiral and was very detrimental to her mental health and also her physical health. I was able to proceed without her testimony at trial.
I like your writings, your sample. Very good. So you like to write.
Yes.
So why don't you tell us about that case?
So that was actually a rape case as well. It was something that you don't see all that often. It's called a Frank's motion, where the defense attorney was requesting that evidence be suppressed because there was a statement in an affidavit that was intentionally untruthful or misleading. And we had there needs to be a preliminary showing to entitle the defense to an evidentiary hearing in that case. In that particular case, in order to save time and for judicial economy, we did both hearings together, and then the judge ultimately decided that the defense had not met the standard to get the evidentiary hearing.
What is, when you look back, what is the most complex case that you had that comes to mind?
I would say that most of my cases have
All of them.
have a complexity. Each case has a different complexity. I, as you mentioned, have had cases, sexual assault cases, for example, with a disabled victim, and the complex issue in that case may be figuring out how to get this individual through the trial. How am I going to be able to let them tell their story in court and have accommodations for them that will allow them to do that?
So, looking back, and you look at all these cases, was there one that you lost that'll always be in your mind that you wonder if it could have been a different judge, it could have gone a different way?
So I don't necessarily rather look at cases in terms of winning or losing, because I think often the most important part, either for a victim or for the defendant, is the opportunity to tell their story. And I think the reason why a lot of cases don't resolve short of trial is because these people need to go to court and tell their story. So I don't really, the disappointments I've had in my cases aren't really result driven.
Do you think there's racial discrimination in our courts?
I think that the courts are doing the best they can to address these issues. I think we can always do better. I think with more education, not just for judges and attorneys, but for all of the court staff, we can do a better job on addressing these issues in the judicial system.
Can I tell you my opinion? I'm not an attorney. I'm a full-time governor's counselor. And I go out to the prisons and I meet with inmates who are petitioning for commutations. And after I talk, and they're black men, they're discriminated against. And I have gone into my car and just cried because it is so horrific what they've gone through. One fella, he was 20 years old. And he was and never had any criminal record or anything. He did well in school. He was just a good person. And he went out with a older friend, 26 years old, and they stopped at this house and they went in. And his friend went into another part of the house, and I'll give the name, William, did not know that his friend stabbed someone 12 times, stabbed him to death. He had no knowledge of it. They went out of that house, went home, he had no knowledge of it. William was sentenced life in prison without parole. I know that's the law. They should look at these laws and change them. He wasn't beside him, he wasn't in the room, he didn't even know. So this is what I see. And all I can think of is how many Black men in prison don't have an advocate to have a commutation. And that's what I'm concerned about. I really am. And then on the other thing, the parole board, and I don't think judges or anyone are looking at that. I am, and we have to increase it. There's only 7, and we need 9, because they're going from the western part of the state to the Cape, and they're burnt out. And the thing is, they have to give time to the hearings and to give a timely decision. And the thing is, they don't have time for the LIPA hearings or commutation or pardon hearings. And that's what I'm concerned about. And I've talked with the governor about it, and she's partnering with me to get more commutations. But that's the fact. And I know it's wrong. How am I going to change it? But I think that legislation, if we could get legislation through, I think that would help so that we could have some justice for these people. So are you involved at all in any of that process as far as people that have gone to prison that you have, you have probably represented?
I have not personally been involved in any parole hearings for clients that I represented. Unfortunately, the clients that come to mind who went to state prison when I was a defense attorney, they're probably not parole eligible yet, the ones that come to mind, so I haven't been personally involved in those. But I do often think about some of my clients who took a rather lengthy sentence in order to avoid, as you talked about, a life sentence without me.
Yeah, 20 years old, he's 54 years old now. And so when I met with William, I said to him, "I'll get you that commutation, and when you get out, I'm bringing you to an Italian restaurant in Watertown." And I did, and I'll never forget it. And he was only out about 3 or 4 months, and I didn't want to cry, but it really touched me. I said to him, "William, what was the most important thing that's happened to you since you've been released?" And you know what he said? "Marilyn, I've got my driver's license." How we take it for granted, so I'm just saying that how many will never know in prison, and we're not going to be able to address them all, and that's it. But I think, I don't know, I'm upset with some of these judges, and I think it's not equal all justice. And I was so upset, getting back to Harmony's case and what that judge did when he knew the father was a vicious man. He shot someone in the head. He's been in prison, and he even admitted that he was beating up this child and having her clean the toilet with a personal toothbrush. It was horrible. And she was disabled. She was blind in one eye. And when I look at that and I say, what is a judge thinking when they're doing something like that? And so I called Judge Butt, and I says, I want him removed from the recall. And I found out he wasn't. So I'm just saying that it could have stopped there. So I don't know, there seems to me, and it's not up to you, there should be a review of judges. We in the council have an industrial accident board, and we have a review when they're up for reappointment. And it's like a report card, and it's wonderful, because part of it is questions of, has there been any questions of discrimination? Has there been any complaints from attorneys or whatever? So it's good, it's a report card, so you know if they really are, you know, the kind of judge that should be there. So I wish we had that, you know, for all judges. I'll get off my soapbox, but the thing is that I really was impressed with, you know, I don't know how you sleep at night. I mean, these cases, I just unbelievable. But we need someone like you that has done the work, and you know, and I also got a letter from Julie. I'm going to screw this.
Bazuski.
Say it for me.
It's Julie Bazuski.
Yeah, okay. So she wrote a letter and talking about, you know, how she's worked with you and the child abuse unit, and all about your, you know, how you treat everyone the same, and you've gone the extra mile. It's a beautiful letter, and also, you know, to know from these people who work with you, just what you do. But I'm even meeting with you to get to know you. It was very important to me, and I felt that too. So I'm going to be very pleased next Wednesday to make a motion for your appointment, and I think I'm sure it'll be very favorable, and you had wonderful witnesses. You couldn't have gone the best, really. So I'm very pleased with that, and thank you all for coming, and I'm going to adjourn.
Now, can I leave